Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we'll be discussing the concept of mitigation. So in the legal concept, the idea of mitigation is the expectation that the individual who has been impacted by some improper act has to take reasonable steps to lessen the harm that is being incurred on them. And when you apply this to an employee termination situation, the expectation is that the employee, being yourself, even though you've been terminated, you need to undertake to find alternate comparable employment so that you address the financial losses that you have been incurring as a result of your loss of employment. So this is particularly important if you are intending to challenge your former employer with respect to the terms of your termination and severance, because if you're going before the court, you can expect your adversary, which is your former employer, and their lawyer to raise legal concepts that are of pertinence to the court, and they're making any determination. So the one that we're looking at right now is a concept of mitigation. And what you're attempting to do in the mitigation process is to establish, and this is the key, establish, and this is through attaining a record and confirming whether it's through letters or emails or your attempts to obtain comparable employment to that employment which you lost. Critical to this concept is that you're pursuing comparable employment. You got to be searching for it. Even your search results, you want to make a record of it. But you do not need to be pursuing employment that is less than your comparable employment, at least at the outset, for purposes of your court action. Because what the court is saying is that you need to mitigate, and you need to mitigate at a comparable level. So if you're a senior advisor in a company, you don't necessarily need to take on a junior position. Your former employer is effectively on the hook if all that's available to yourself is that of a junior position. However, should you not have pursued a senior advisor position where that senior advisor position was available, let's say with a competitor, another company, and it was paying a comparable salary, and it was in an available location, then you could find yourself having failed your legal obligation to mitigate, and this produces an issue. And if you had not taken that position because you are making decisions which go outside of your claim, as such, you got two things that you got to be looking at. You got to be looking at pursuing those comparable roles, and should the comparable role arise, which is comparable in its nature, character, salary, and the like, you do have a legal obligation to undertake that position. Recognizing that if you do not take that position, that can be raised against you in court and be brought as a means to reduce the amount of damages that you can claim as against your former employer. That is one of the concepts of mitigation, and this one pertains to an employee termination scenario where you intend to challenge and actually intend to bring to court a claim for wrongful dismissal, constructive dismissal, and seek damages from your former employer. Thank you.